With regard to the abortion law, not only nationwide, but in Tennessee, and Glenn Funk's with us, is, how much discretion does a district attorney have on whether or not they're going to choose to prosecute any type of case? And I bring this up reminding folks that here in Davidson County, if you're caught with less than half an ounce of marijuana, which under state law is illegal, you have been on record saying, I'm not going to prosecute for that. I'm not, and you, by the way, Sheriff Darren Hall agrees with you. I'm not going to prosecute. And a lot of people are, well, it's the law, General. How are you not prosecuting for half an ounce? And now, with regard to abortion, if a case were to come to you here, you have discretion, correct? It's not like, well, it's the law, I have to. Well, how does discretion play in with this Quillen versus Crockett?
Right. So, the district attorney is a constitutional officer, right? When our Constitution was written in 1871, they established under the judicial branch of our Constitution that district attorneys will be elected by the judicial district every 8 years. Right? And the district attorney is empowered to decide which cases to prosecute, which cases not to prosecute. Right? And essentially what the case law interpreting that is that a district attorney is empowered, is the only person in the county with the power to ask for a person to be incarcerated, right?
Mm-hmm.
Right? We don't want just anybody being able to put anybody else in jail, right?
That makes you the most powerful person in the county because you can take away my freedom.
Well, but there's a bunch of checks on that power,
I know there
right?
Are. Sure.
There's a check. The judge has to approve the warrant. A general sessions judge has to bind the case over the grand jury. The grand jury has to indict. A criminal court judge has to allow the case to proceed, and a petty jury actually decides guilt or innocence. And then even after that, right, you can still appeal to the Court of Criminal Appeals and to the Supreme Court, and then the federal courts can weigh in too. So there's a ton of checks on my ability to put you in jail. What about my ability to decide not to prosecute you? Well, if I just don't show up for court, the Constitution says the judges can appoint a pro tem to come in, right? Back in the 1870s, I imagine there were some district attorneys who also were farmers or merchants, and it wasn't a full-time job to them. Maybe some of them didn't show up for court. They anticipated that if the DA doesn't even show up, judges, you select somebody until the next election.
Interesting.
Also, if there's a district attorney who's corrupt, who's taking bribes, or is doing for corrupt purposes, right? Well, then the legislature could impeach that person, right? But other than that, you got to look to the courts who have interpreted what the Constitution says. And there's a lot that say, listen, district attorney has the right to decide charge or no charge without veto by anybody, by any court, right? That's specifically under our Constitution given to the district attorney. The graphic that y'all have, Quillen versus Crockett, had some really significant quotes in there. The district attorney general is an arbiter, and in many cases an umpire between the people and the people's government, right? So let's say that for whatever reason, our legislature said, you know what, it is a crime to have blue eyes, right? Well, you know what, I need to be an umpire between the people and the government to say, you know what, we're not going to put people in jail just for having blue eyes, right?
So even if they pass that kind of law at the state level, right, you're an umpire between it.
Right. Right, that's what the case law says as far as what the way our Constitution was written here in the state of Tennessee.
So you can, okay, so even though the law is on the books, if you don't think the law is right or just, you can...
Then my role, my duty as a prosecutor is to be an arbiter between our government and the people.
Now, if you choose to do that and upset the state legislature, can they send in a judge or a DA pro tem to replace you?
They
could try.
They passed a law, right, a couple of years ago that said if a district attorney says they're blanket not going to prosecute certain crimes, that they can come in and ask a judge to appoint a special prosecutor to come in. But a state law cannot trump the Constitution, and the Constitution says what the Constitution means, right? And
so you don't think it would work if they tried to remove you?
Well, I think the case law is very consistent, right? Also in Quillen versus Crockett, and this is repeated a dozen times in case law, our constitutional system of government vests the prosecutor in his or her own district the power and the authority to make charging decisions without veto. We saw some prosecutors when the governor did a mask mandate, some prosecutors in East Tennessee that said, well, we're not going to charge anybody for that violation. Right. here and the prior prosecutor in Chattanooga also, we're not going to prosecute marijuana for less than half an ounce. It's about using the resources of our office to try to make sure that the community's safe. And this is a situation where not only are we trying to focus our resources on violent crime, on trying to make the community safe, but it's also being an arbiter between the people and the people's government. And then the check on a prosecutor's power
is the voter.
Is the voter.
Yep.
I said 2 years ago in a federal court filing, right, that I was not going to prosecute a woman or her doctor for making a medical decision regarding terminating a pregnancy. Right? I said it again the night before the election when the Dobbs decision that overturned Roe v. Wade first got leaked. I said it again. Right? The voters in this judicial district elected me, right? Knowing what my position was, right? And here under prior case law, if voters are in disagreement with the prosecutor's charging determinations, they have the ultimate veto at the ballot box. Other case law talks about how a court, no court, right? The quote is, no court, right, has the power to interfere with a charging decision. Right now, once the charging decision is made, a court can dismiss a case if I'm trying to put somebody in jail and the court disagrees, right? But no court can exercise, can interfere with a prosecutor's charging decision. What that statute does is that says that the Attorney General can go to the Supreme Court and have the court then bring in a pro tem, i.e. interfere with the prosecutor's charging decision. So whether it's a situation where I choose not to prosecute the case, or whether it's a prosecutor in some other county in Tennessee deciding to bring some sort of very severe charges in an abortion case, you know what? The checks and balances in the system are ballot box, corruption, right, or no-show, and if it's about overcharging, then the checks and balances are not only ballot box, but then judges and juries and courts of appeals. And
so we understand, and politics always play a role in this, that you were elected here in Davidson County, and everyone knew your stand on it, and so apparently they're in favor of it. There's DAs in other counties around the state where the voters feel very differently about that issue and probably would be upset with them if they chose not to prosecute and they could vote them out. But I'm guessing many of those DAs will be ready to prosecute if a case comes across their desk.
I don't know exactly where every one of the 32 elected DAs around the state stand. I know that there is a broad range of opinion when it comes to abortion. But if the legislature has passed a law saying that a certain behavior is against the law, if the voters of that judicial district have put that person as the district attorney, then that person makes the call in that judicial district.
Let's take a call from James. Good morning, James. Hi, James.
Good morning, guys. I think you're excellent, DA.
Thanks.
My question here is, what do you do when it's your daughter? And that's the way I feel about this, because I have a daughter and I'm concerned for her safety and medical rights. I kind of feel like we need to move as a people to a voting apparatus that says, all right, you have a set of rights, medical rights, that we cannot step in and change. These are your medical rights as a female. These are your medical rights as a male. And government or judicial cannot step in and say, all right, this goes this way and this goes this way. It should be that woman's choice or man.
Love that comment. I think framing it as a medical rights determination, I think that is an excellent way to phrase this, whether that comes in the form of a statute or a constitutional amendment. Clearly, I think that a person should have essentially the right to determine what goes on with their body, in their body, and I think especially when you're doing that in conjunction with medical advice and receiving proper medical care, I think you're exactly right. The question, what if it's your daughter? Well, you know what, if it's my daughter, I love her unconditionally, and if she's in this situation, I don't get a vote. That's her decision, and my job is to love her no matter what her decision is.
Moving forward, okay, I'm just wondering, it's only 2 months in, okay, so it's still very early. I guess as you are evaluating this, what do we see happening moving forward? I mean, you believe there will be a test case?
Well, we're still real early. It's not like anybody's going to rush to the courthouse the second they hear that somebody has taken the 2-pill regimen after, in September or October. What'll happen is there will be a situation, whether it's an actual surgical abortion that's performed at a hospital, which I can only think that the only reason why you would have a surgical abortion is if the fetus is really causing threat to the life of the mother. Even a fetus that has like a trisomy 14 that can sometimes be born, live a few days or a few hours, but then die. Down syndrome's trisomy 21, and so most of those children still live. I've got a son with Down syndrome. He's the greatest, by the way. But if it's a trisomy where there's 3 chromosomes of one of the pairs, the larger the chromosome, the less likely it is that the baby can survive, and some of them it turns into a miscarriage. And so that could lead to a potential surgical abortion, but probably it would be a life of the mother, and then after only a lot of discussion within the hospital at the time. But more than anything, I think it's going to be one of these cases with the 2-pill medical abortion. And so once that happens, then there will be some form of an investigation. It'll be taken to a district attorney, and I think we're probably 9 months to a year before anybody have to really make the hard decision, go, no go. Do we make the charge? Do we not make the charge? And so I would expect, by next summer, certainly by this time next year, we will have had those cross the desks of some district attorneys across the state. And then we'll know, and we'll be able to follow what happens if and when a district attorney decides to go forward with the prosecution.
It's interesting when you talk about when that is considered a life at conception at that moment. It brings up, and I know you deal with criminal, but we were thinking, and someone else had mentioned to me about the fact that a rapist could, under these guidelines, we already know that if a woman's raped and is pregnant, they're going to be forced to have the child. They will not be able to get an abortion. But if somehow they did, this rapist could sue the woman he raped civilly over this child. I mean, would that be the case?
At what point do parental rights attach to the father? Right? Yeah. Well, I guess they don't attach to the father until this zygote is a person, which, of course, under Tennessee law, the zygote is a person at fertilization, and so then parental rights would be attached to the father at that point. Why would this rapist have any rights at all over this child? And why would this rapist have any rights at all over the woman that he impregnated? It's beyond me why we would give those rights to anybody like that.
But do you agree that would be a possibility under the law the way this is?
I think it's clearly a possibility. I'm just a lawyer. I'm not a judge, right? I'm certainly not a Supreme Court justice, right? But at some point, those types of issues are going to go in front of the Supreme Court, and if they read the plain meaning, it cannot be any more plain than life begins at conception, and then fertilization means that point in time when a sperm penetrates an egg. So it can't be any more clear than that. And so how will the Supreme Court treat a future case like that? Yeah, that'll be up to them. But
that's just hard to imagine,
right?
In a situation, it's a very difficult situation. Let's go to Elsie. Elsie, good morning. Hi, Elsie.
Good morning. I've got a comment and a question for the district attorney, who I do appreciate you coming on to give us a civics lesson here this morning. I think we need a good hard one. But my first comment is that rapists have gotten visitation rights in this country to their quote-unquote children through the courts. And when they got out of jail, they forced this upon their victims that they raped that decided to keep the babies. The second thing is, District Attorney Funk, this is what I don't understand. I studied science in school. Maybe we ought to get that out of public school and we wouldn't have this problem. But from what I understand, I do not understand Tennessee's so-called heartbeat bill when there is no heart at 6 weeks. There's only a cell. And the heart, you can't take a heart out of a fetus. I forget how many weeks. I think it's close to 2 months before there is an actual chambered heart that will give you a heartbeat. So I have an issue with this crap from the beginning. I think it makes us look absolutely stupid here in the state of Tennessee. And I'm just so sick and tired of hearing this. And I have been one of those people with medical issues that my doctor told me to never have a child. And I got pregnant twice, practicing birth control, and had to go through that fear until I had 2 miscarriages. And not only that, when I asked my doctor this decades ago, if that's the case, I can stroke out or die, leave a child or something like that without a mother, then tie my tubes. He said, you can't do that unless your husband gives you permission and you're not married yet. Thank you.
Your thoughts?
Yeah, well, we had a lot of issues thrown in that conversation. As Tennessee's legislature considered abortion over the last 10, 15 years, at one point we had a heartbeat bill, which said that as soon as you could hear a heartbeat, then that was presumed to be the time that this was a person. And in fact, we had a kind of a stair-step act passed about 6, 7 years ago, anticipating that maybe Roe versus Wade would be overturned. And they were anticipating that the Supreme Court might make it illegal at 16 weeks, at 14, 12, 10, 8, whenever. And so we had this stair step to where if the Supreme Court had set a limit, right? I mean, what the Mississippi case, Dobbs, really was about was the 16-week constitutional or not. And they could have said 16 weeks, and then instantly our trigger would have said 16 weeks. But then a couple years later, the legislature said, well, what if they just throw it all out, just completely overrule Roe versus Wade? And so they put this other statute in that said life begins at conception. And so if the Supreme Court had set it at heartbeat or set it at 8 or 10 weeks, then our law was already in place to take it as low as could go. But then we had this separate section that said, but if they throw it all the way out, life begins at conception, and it's instantly illegal. So the heartbeat law that we passed a number of years ago, that is obsolete. It's completely overwritten by the current statute, which says at fertilization.
Take a break on that note. We come back, our final segment with District Attorney General Glenn Funk. We can take more calls, more comments on Facebook right after this. Stay with us.